Good evening, everybody. I'm Brian Valentino, Bri, the Poli-Sci guy. It is 5 o'clock in the afternoon on Tuesday, February 13th, or Monday, February 13th if you prefer. And we're going to be talking today about the separation of powers doctrine and the idea that we divide up the powers of our federal government amongst the different branches of government. And how do we exercise the power of government in a way that allows us to check the power of certain branches and then also balance the power of certain branches. So in order to understand this, we're going to go back in time. We're going to go back to our American history class. We're going to go back to the Revolutionary War and remember that the United States of America was founded on the premise that we did not trust a strong executive, and specifically at that time we did not trust a king, a monarch. But it was always really more complicated than that, but we were taught that in elementary school to make it easy to understand. We did not think that a king had any power over us as individuals, and therefore we wanted to elect our own leaders, and we wanted to divide that power up amongst different people so that no one person had all the power. The way that we did that was actually more deeply rooted in the problems of the revolution. If we consider the fact that the rallying cry of the revolution, or so we were taught, was no taxation without representation. Well, if we're truly opposed to a strong central leader, the king, then what representation are we talking about? Surely we have no representation in the monarch. And what the colonists were talking about is they wanted representation in Parliament, which as British citizens they felt that they were entitled to. However, the British citizens who were represented in Parliament didn't want to give a vote to the people across the sea in the colonies. So what we were really objecting to was the entire way that the colonies were being administered by Great Britain. And if we can appreciate that, then we can appreciate why the founders in the Constitution of 1787 divided up power the way that they did. So first we have to ask ourselves a question. I think I've asked this before, but we'll check again. All of you are smart people. You all went through good schools. So the question I will ask you is, who was the first president of the United States? And of course, we look and the first answer everybody says, well, it's George Washington. And I will tell you, no, George Washington wasn't the first president of the United States. He wasn't even the 5th president of the United States. If we consider that the Declaration of Independence is what established the United States of America, then the president of Congress, who at the time was anybody? You want to write an answer down? Rich Dalton instead of giving me a hard time? Anybody? Big signature? John Hancock was the president of the Continental Congress in 1776. And when we declared our independence from Great Britain, he therefore would have been de facto the first president of the United States. But nobody thinks about that. Then we go ahead and our first form of government under the, when we were our own country, was the Articles of Confederation, which was our first stab at a constitution. And there were multiple, school has an update. Threw me all off. The Articles of Confederation were our first stab at a constitution. Again, we were scared of a strong executive. We were scared of government. So the Articles of Confederation were such that the states each sent one delegate to the Continental Congress, and that Congress would then govern the entire country. But the centralized federal government had almost no power whatsoever. They couldn't do anything together. Each state still had their own money system. Each state had their own militia system. It really didn't work. So we threw that away within 10 years. And in 1787, we adopted our new Constitution, the Constitution that we operate under today. They learned their lessons from the king. They learned their lessons from Parliament. They learned their lessons from the lousy Articles of Confederation. And we start out with a new system of government that divides power amongst 3 branches of government. In Article 1 of the Constitution, we established the legislative branch, or the lawmaking, policy-making branch of government. In Article 2 of the Constitution, we established a strong executive branch, or the presidency, and all of the federal departments that come underneath that. And in Article 3, we established an independent judiciary, an independent judicial branch. That was topped by a Supreme Court, which we talked about this last time, and then all of the federal courts that Congress may create after the Supreme Court. So all of the powers of government are now exercised by 3 branches of government instead of just 1 branch. This was the first time this was ever done. There had never been that government had been broken up into different branches and power given to this group or that group. And some powers were enumerated. They were expressly given to 1 branch. So for instance, we all know that the power to declare war is a power that's expressly given to Congress. Congress must pass the law for us to declare war on another country. That's an expressed power. But a lot of the really important powers, the powers that could affect our rights as individual citizens, the founders broke those powers up and said, we're not going to give that power to any 1 branch of government. And when I was still teaching political science and American government at the college level, I would explain this to our students, thinking about a good Cold War movie, whether it be in a submarine or a missile silo. And what you would do is there would be 2 people operating the missile zone. They each had a key, and both of those keys had to be inserted and turned at exactly the same time in order for the missile to launch. And it's very similar when we think about how we exercise the powers of government. It takes 2 branches working together to make our government work, which should be your first indication as to why so many of us think that our government just doesn't work right now. Congress has to work together in order to make these things, make our government work. So Congress and the president, or the president and the judicial branch, have to work together, or none of this is going to fly. So let's talk about what some of them are. The president has the power to appoint the officers of the government, but he can't use that power without the Senate, a portion of the legislative branch. The Senate must give the president his advice, and the Senate must give the president their consent before they can appoint, before the president can appoint an officer to the government. So that's one example. Congress has the power to make laws. However, the power to put the law into effect lies with the president. Congress passes the law, it then goes to the president, who must sign the law. The president fails to sign the law, one of several things happen. It might go back to Congress, who can then override the president's veto. Should he veto it, the president could do nothing, and in 10 days it becomes law. And at the end of a congressional session, if the president does nothing, it becomes law. It doesn't become law. It's considered a pocket veto and doesn't become law without the president taking any action. The one we're going to talk about a lot today, however, is what's happened in the last couple of weeks with the president issuing this executive order, or a series of executive orders. And one in particular has gained our interest, right? The president issued an executive order barring, in a limited way, the immigration of certain people from a list of very specific countries. And this has was issued by the president. Several states on the West Coast took that case to federal court, which is where it would go because it's a federal law. It was tried in a trial court. It was found that the states were correct by the trial court, and they ordered the president to immediately suspend his executive order pending further review. The president's attorneys, on behalf of the federal government, then took you like that, Jim? Then took that law and went right up to the Circuit Court of Appeals, which is the Federal Appellate Division. The Circuit Court of Appeals, in the Ninth Circuit, reviewed the case and famously upheld the case from the lower court. We'll talk in a few minutes about why they upheld that. It's not important to this conversation, but what people were saying is the president has a law. The president has a law that specifically gives him the power to suspend immigration from any country or any group of people that the president deems as a threat. And so the states were arguing that it impacted their operations and their people in a negative way, in an unconstitutional way. And what that allowed the court to do was now judge the executive order based on the arguments of both the states that were negatively impacted and the administration's argument. The news media has made a lot of comment about what portion of the case was really applied, why the ruling went the way it did, and people are all up in arms having an argument about whether the president's still right or the court's trying to make law from the bench. There's arguments for all those positions. You can be right and you can be wrong in the same conversation. We are really in somewhat uncharted territory here as far as the president's use of his powers and as quickly as he's using the powers. But as always in Bry the Poli-Sci Guy, we're going to try and take the politics out of it, and we're going to just look at it on its merits. So let's start with the arguments of the state. The state's arguments were that the president did not have the power to suspend the immigration of these people in a way that negatively impacted the legal rights of those states and those residents. Now, someone earlier today asked me a question and said, that law says the president can suspend immigration and those people are entitled to due process, but the right to due process only applies to citizens. Not true. The Constitution and the right of due process applies to anyone who is subject to the laws of the United States. So if you are here, if you are on U.S. soil, the Constitution applies to you. The example that is most easy for people to understand is Guantanamo Bay and the terrorist detention center in Guantanamo Bay. That exists because the Bush administration's argument during the war on terror after 9/11 was to get all of those people off U.S. soil and onto another country's soil where the Constitution would not apply to them. Many political scientists and legal scholars argued that the Constitution is in effect at a military base. The argument that has prevailed is that no, that's military law and not civil law. The Constitution doesn't apply there. That's kind of decided law. But if these people are at a U.S. airport, on U.S. soil, in a U.S. district of any kind, whether that be a state or a federal protectorate of any kind, the Constitution applies and they are entitled to due process. So if you are a green card holder and you have a legal right to be in the United States based on that green card, and you are at a U.S. airport, the Constitution applies to you. I'm not making any arguments as to whether those people should be sent home or not. What I am saying is the Constitution applies to them. The administration, the president and his administration argued that no, I have a law. The president has a law. The president's allowed to do this specifically. Congress passed a law that gives this president these specific powers. We would call that an implied power of the president because Congress has specifically allowed something. But the president is exercising his power in a way, according to the court, where he has not shown that there is a need for him to do that. And the law actually requires the president to show a need. The president feels that that need is obvious, and his lawyers argued that, well, we all know there's a problem, and the American people have spoken and voted and installed the president saying that there is a problem. The court demurred on that point and said, president might have reasons for it, but he hasn't shown them to the court. Therefore, the ban is upheld. Now, the president has two choices now. The court has ruled that the ban must stay, is stayed, which means it's not in effect. The ban is not in effect. And the president can either continue to appeal that case up to the Supreme Court, or he can choose to abandon the argument, allowing the states to win this case. And then he could take away his old executive order, rescind it, and issue a new executive order that might meet judicial muster. One of the arguments that the president made was that the court did not have the legal ability to review the actions of the president in regards to this executive order. The court did not buy that argument either. As a political scientist, I don't buy that. There's a long string of judicial cases that clearly state that the court can review the actions of the executive branch. There's only some cases that some powers that the president has that are absolute. Those are called expressed powers of the president. He can govern the military. He can convene and adjourn Congress. He can veto laws. He can pardon people. He can appoint ambassadors. All of those things that he is expressly allowed to do, the courts can't review. But anything else, any other power that he has, if they're an implied or inherent power, that's subject to judicial review. Always has been. We go back to Marbury versus Madison, the famous Supreme Court case, and I think it was 1802 or 1803, establishing the power of judicial review. The country has absolutely relied on that power ever since. There's been, you can go back to look at the Federalist Papers, where clearly the intention of the founders was that the judiciary should be independent and should be able to review the acts of the other government. That's our check as the people to make sure that our executive is acting appropriately and our legislature is acting appropriately. So that argument is yet to be seen. Now, a lot of people said, oh, wait till it gets to the Supreme Court. Yeah, we have to wait till it gets to the Supreme Court. I get that. But the Supreme Court is most likely going to either send it back to the lower court and say, you guys review it. This doesn't need our review. Or they're going to judge it on the merits of the case as it's existed so far. And while the Supreme Court has traditionally sided with the president in cases of national security, the lower court has basically said, you haven't shown us that this is a national security matter. So I don't know how it'll go. And remember, we don't have a full Supreme Court. We only have 8 justices, and they're divided ideologically 4-4, 4 Republicans, 4 Democrats. I don't know where that goes. I think we can also expand the separation of powers a little bit and look at the fact that we've also put into the Constitution a very strong power in the First Amendment for the press to be independent, the independence of the journalists and the newspapers, et cetera, of our country. We did that so that a future government could not bar the press from covering the actions of government. As our eyes and ears, the press should be allowed to cover our government. You're seeing a lot of kickback against that. There's just no other way to put it. This president does not like the media. This government has shown itself in the last 3 weeks to be very much opposed to government covering them in an open way. It's been adversarial. Certainly Saturday Night Live is covering that in a way that is bringing that home. If you're not aware of it, just watch Saturday Night Live. It'll tell you everything you need to know. So we need the press to cover that. And that, while it's not an expressed power of government, that right of freedom of the press is really important to how our government operates successfully. We also have given the power to the people in the 10th Amendment. Any powers the government doesn't have are expressly given straight to the people. If the states don't take it, then the people get it. The power of the people to petition government for change of power. The right of the people to speak openly and freely without any single problem of worry about getting locked up. All these powers were given to the people so that they could speak up and say the government's acting inappropriately, or the government's acting appropriately, and I think you're wrong, other person yelling and screaming in the street. But we're seeing a government that's really doing a lot to try to stop that and to belittle that, which is certainly the right of the people in government to do. I just, as a political scientist, editorial trigger warning, as a political scientist, I'm telling you, my read of the Constitution says that that's not what the founders intended, and it's certainly not what I as an American expect to see. End of editorial. I'm going to take some questions now and see what I've missed here. and then if we don't see anything good, we'll come back to it. Let's see here. Mike Solano, first of all, excellent work with the reporter. I'm very proud of you. That was very grown up of you. Mike Solano, Eagle Scout extraordinary and head coach of the winning Freehold Township hockey team, asks, can a state impose an additional tax to cover a shortfall in the event the federal government halts monies to sanctuary cities? States can do anything they want in terms of their own taxation, yes. Let's see. Who else here? Stacy Stefanski and her son Robert can't talk to each other because he's smarter than she is. We know that, Stacy. Don't tell us something we don't know. Alec Baldwin does a great impression of mannerisms. Thank you, Kim. I will make a note of that. Any other questions, please post them. There's 7 of you who hung in here to the end. Good job. I guess what I'm going to say here is that to close out, the responsibility to check the president and to correct the problems with our immigration laws, while it is the president's right to act in the administration of government, immigration laws passed by Congress. And if we really want to grow up about all this, Congress needs to act. Congress needs to take the president's intentions and turn them into laws. That way, it's vetted by both parties, it's vetted by the public. There'll be hearings done in public. And then when the Supreme Court rules, the Supreme Court's ruling about a specific law that's been passed, rather than dealing with an executive order, which really is only direction to a federal department. That's not a law at all. Kim Dalton asks, what about homegrown terrorists? What branch handles them? The executive branch absolutely is in charge of law enforcement, period about that. If Congress were to pass a law that stipulated something to the contrary, it would be open to review by the judiciary, and they would say whether the president was, or Congress's law was constitutional or not. Yes, Stacy, I'll come talk to the center on one of my days off. Happy to do it. Any other questions? I don't see any here. So you can email me if you want, and I will be happy to answer your questions. Otherwise, we have come to the end of today's lesson. So thank you all for tuning in. If you haven't looked at that video that I posted from the advisor to the president, you absolutely should look at that. That's some good television. Hey guys, have a great night. And for those of you up in New England who are suffering through the blizzard, and those of you out in California who are dealing with flooding from the dam, be safe and take care of yourselves. We'll talk to you soon. Bye.